Thank you for attending a big reset, impact of SB 56, rescheduling and antitrust action on Ohio's marijuana and hemp industries and their consumers. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for the event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, the event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. The link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you so much, Holly, and thank you to all the attendees, and about to say thanks to our panelists, who I will be introducing momentarily. First, myself, I'm Doug Berman. I'm a professor here at the Ohio State University Moritz College of Law, and I also help to direct the Drug Enforcement and Policy Center, and incredibly grateful to Holly and Yana and everyone over at the center to help us put these programs together. And again, very grateful you were able to join us today at a particularly exciting, although maybe not exciting for everybody, time when Ohio law, federal law on cannabis remains in transition. I guess I probably could say that for the last 15, 20 years, but we were very fortunate to get a terrific group of folks to help us have some perspective on what SB 56, the recently now in place and operative change to Ohio's cannabis laws, mean and represent, and then we'll look to what still seems to be a pending effort at federal rescheduling, and then hopefully have some incredible wisdom looking forward to wrap up our conversation. As Holly mentioned, you can use the Q&A. I'll be trying to keep track of that while others are speaking to make sure we cover all the issues that are of interest to those attending. And so without further ado, I will briefly introduce each of our panelists and then turn to them to say a little bit more about their background and their perspective as we then launch into some more specific questions that I've prepared. So I'll start and go in the order that we have it on the promotion. Ben Bottomer, Foley and Lardner partner, been affiliated with the center for some time, and incredibly grateful he can join us. Ben, why don't you talk a little bit about your background and work, and then we'll get to the others.
Yeah, absolutely. And thanks so much to you and to the center for the opportunity. It's always great to be a part of these conversations. I've been interested in drug policy since roughly the year 2000, undergraduate pursuit where I actually studied hallucinogenic toad use in pre-Columbian Mesoamerica. So fast forward that to trying to make sense of SB 56, I think they're roughly as discernible in terms of what's straightforward and what isn't. I'm, as you mentioned, a partner in the Boston office of Foley & Lardner, Ohio licensed. I have taught through your graces a course on cannabis businesses, regulated cannabis businesses at the Drug Enforcement and Policy Center and at the Ohio State University Moritz College of Law. And I'm actually an owner operator via BCR Holdings, which operates under the retail brand Terrasana. So a lot of personal interest, longstanding interest in the topic. Thrilled to be here.
Thank you so much, Ben. Now we'll go over to Adrienne Robbins, who's the Deputy Executive Director of the Ohio Cannabis Coalition. Go ahead, Adrienne. Tell us more about your background.
Yeah, thanks so much for having me. So I represent OCAN. We are the trade association for Ohio's licensed cannabis operators, as well as ancillary business that work alongside them, meaning armored vehicles, attorneys, CPAs, you kind of name it, and those are our members. But overall, we represent the licensed cannabis industry and their interests.
Fantastic. Thank you very much. Now I'll turn to Wesley Bryant, who is the founder and CEO of 420 Craft Beverages. Go ahead, Wesley.
First off, thank you for having me, everybody. I'm looking forward to this discussion today. I own a company called Titan Logistics Group. We DBA with 420 Craft Beverages. We are a beverage manufacturer here in Ohio. Affected by SB 56, our doors are essentially closed as of today. Or I should say our Ohio operations. As far as I've been in the space since 2013. When I got back from Afghanistan, I jumped right into the space and have been head up ever since, and worked in multiple markets across the U.S., Colorado, California, Oregon, now here in Ohio, as well as the Carolinas. And we are looking forward to the future and what it might bring. With SB 56 closing the doors on production here in Ohio, it's going to be a tough transition, but we have clients all across the U.S., so we'll stay alive, just not in the Ohio market currently in the hemp space.
Very well. Thank you, Wesley. I appreciate it. And last but certainly not least, we've got Tom Herron, who's a partner at Franz Ward. And again, happy to hear what you want to say about your background. As voluminous as everybody else here as well, but go ahead, Tom.
Yeah, thanks, Professor, and thanks to the Drug Enforcement Policy Center for allowing me to join the panel here today. My name's Tom Herron. I'm a partner here at Franz Ward, where I chair our firm's cannabis practice. We've been representing folks in the industry since 2016, 2017, when the Ohio program launched. We now have 5 partners here at the firm. 100% of what we do is representing cannabis companies all over the country. And I had the privilege of also serving as the spokesperson for the Issue 2 campaign from 21 until following the election in 2023.
Thank you, Tom. And that's a useful bridge to what I guess I'm going to call my sort of jump ball first question. We're still in March Madness, so I apologize ahead of time if I use too many basketball metaphors these days. But, since literally voters approved Issue 2 and brought adult use marijuana reform to Ohio fully, we've heard from the General Assembly and the governor about changes they wanted to make to what the voter approved. And through a variety of different bills, the budget bill and others along the way, some changes were made, but this really culminated in what is known as SB 56, the major bill passed late last year and coming into effect just earlier this month, which has really too many changes, both to hemp products and marijuana products and their operators, of course, and consumers. I want to start with sort of a take on, and we can't cover everything, but I'm especially eager to hear from each of you what you view as sort of the biggest component, the biggest change for industry players. I think, Wesley, maybe you would start because you already spoke to it, but I want to make sure you can explain the background for folks who may be on the webinar and don't know exactly why you've had to close your doors as an industry player here. And I especially also want to kind of hear, how you think those changes are going to have impacts and be consequential over the next, 6 to 12 months period. Over the next year, obviously things can change. Maybe, Wesley, you start and say whether you're working to change things at this point, but go ahead.
I would say we're definitely working to change things. Issue 2 at its basis was regulate marijuana like alcohol. I don't think that's what we got with Senate Bill 56. I think it's quite the opposite. While I can honestly say there's some bad actors in the market as far as the hemp space goes, I think if you look a little bit deeper into Ohio's market, we actually had an ODA approved program through the Department of Agriculture. All of our products go through the same scrutiny testing wise as the medical marijuana and recreational marijuana testing goes. And I'm talking about the inner ODA market, not the broader smoke shop, vape shop market. I think we kind of got left out in the dust as things are progressing forward here. So, it's in our best interest to try to change some things to maybe bring some solidarity back to the hemp industry here in Ohio. I work with a farmer here locally as a direct supplier for our goods that go into our beverages. So we are essentially one of the only companies in Ohio that's a full tier hemp beverage company. So we control all of our inputs all the way to the time it meets the customer's lips. I think the controls that we had in place were pretty good. There's some things that could be done a little differently as far as tagging and controls of those products going through the system, similar to what the medical recreational guys are privy to on a daily basis. What you didn't really see here in Ohio was mass amounts of synthetic conversions. All the products that you were getting out of Ohio were naturally based products for the majority of them. Ohio had actually pretty strict standards on what we could do with the product through the process. Ohio didn't have what they call a work in progress. So it's really hard to work with extracts that are high in THC to begin with here in Ohio. So, we've been navigating those waters since 2020 when the program went live. And I think as far as the licensees, we've all got certified kitchens. Most of us are CGMP. I would say mostly very clean operations. So with that being said, I'm hoping that there's some change in the future. There's some, some recognizing that comes along with that shows that, there is a sect of people that we're currently doing it correctly, and we can regulate those products like alcohol. I think the real losers here with SB 56 aren't even myself that had to close a business. I think it comes down to the consumer. These consumers are now pushed into medical recreational dispensaries. A lot of our clients were low dose THC users. We made and created products with as little as 2 milligrams, 2.5 milligrams of THC, up to 50 milligrams of THC in some of our beverages. So we had a fair amount of low dose products that we've produced, and they're very difficult to find within the regulated metric system. And when it comes down to it, even take away meme as far as a full tier system, even the other processors were using inputs from out of state. Same thing that the medical recreational guys use. They use all minors from hemp products. So on one hand, they say the hemp products are dirty and nasty, but yet they buy them and put them into their products and shelf them with inside dispensaries. So I think while there's controls in place for OCAN members to do that, where the disconnect is if they're buying the inputs from the same place we were purchasing inputs from, why so different? So I think as we roll through this conversation, I'm sure we'll hear much more today, but that's kind of where I stand as far as Ohio is right now. And then moving forward, I think we are going to see some general changes on the federal level. We've got the CMS program that just got started earlier. Well, not started yet, but announced a few days ago. That specific language there speaks to 3 milligrams of THC, up to 3 milligrams of THC per serving. That means a tincture bottle, like a full spectrum tincture bottle at, 30
Yeah,
ml.
so I don't want to cut you off, Wesley. I both want to, maybe let Adrian respond on the OCAN frontier, but also we'll get to the federal conversation, the way in which, a variety of things that are going on, not just with pending reschedule, but the other initiatives that the Trump administration has started, how that may echo through the work that you do and the industry more generally. So thanks very much on that, Adrian. Why don't you jump in, and then I'll let our partners add on as we talk about this, whether you call it a disconnect or just ongoing challenge between, hemp operators who, were, as Wesley was describing, tried to be faithful to providing a good product, but outside the regulated channels that had been created under the existing program. And now, as I understand things, SB 56 means only products coming through those channels are going to be permitted.
Well, first of all, I heard on there, what's the difference? Well, the difference is you're not a licensed cannabis operator. If you're going to be selling cannabis, what Ohioans voted for when they voted for issue 2 is to have a controlled, regulated system. They did not ask for the Wild West of anybody being able to sell these products. And I hear you that there are good actors in this space that are testing their products, that are in a safe, secure building. But we actually don't know how many or how much of this market is that, because it's unregulated. That's not what Ohioans asked for. So I think it's really disingenuous when we talk about the referendum campaign and hide behind issue 2 and what Ohioans voted for, when at the end of the day, that's not what Ohioans voted for. And in fact, those who wrote the issue 2 campaign, the campaign itself actually came out against the referendum effort and said that Senate Bill 56 did keep intact what Ohioans ultimately wanted. Again, Ohioans wanted a regulated cannabis operation. They still have that. There are over 200 dispensaries that Ohioans can visit today and know they're getting safe, tested, good products. That's a win for Ohio consumers. What they don't want is for these products, these Delta 8, Delta 10, Chinese hemp products, to be sold down the street from their child's playground. No one ever asked for that.
Thank you, Adrian. I heard reference to the authors of issue 2. So Tom, that seems to be a cue to you to some degree, and let you sort of chime in on both, the conversation we're having, but even the broader question of just other aspects of what you saw in SB 56 and where you think it's taking these players and industries going forward in the state.
Yeah, I mean, look, there's a lot to unpack based already off of where this conversation is sort of headed. Look, I think there is certainly a large category of hemp products, quote unquote hemp products. Some products were marketed as hemp products. They quite frankly were not hemp products at a lot of convenience stores, gas stations, vape shops, etc. And where we ended up, I think, which is a regrettable place to end up, is that there were harmful products being sold at these stores to kids. And you saw them in any of Governor DeWine's press conferences. I would hear about it from friends and family members. Hey, I went and stopped and got gas and I saw, 150 milligram THC per gummy nerd knockoffs behind the counter. Or I stopped at, this gas station and they had marijuana flower behind the counter and it still had the Michigan sticker on it, or it still had the California sticker on it, right? Like, so many of these places were selling products, characterizing them as hemp when they were just diverted marijuana products from other states. And the result of that conduct is that the legislature threw the baby out with the bathwater, largely because that's what happened at the federal level. Like, let's also not forget that where Senate Bill 56 was in the summer of last year and in the fall of last year, was effectively to require intoxicating hemp products to be sold through any number of different channels. And different versions of the bill had them sold either through licensed dispensaries or through sort of regulated hemp dispensaries, et cetera. And then there was a separate carve out for beverage products. But when the appropriations bill at the federal level, I think in September of 2025, came out, and they added a rider to set a basically total THC calculation of what qualified as hemp, right? In 2018, it was only Delta 9 THC plus THCA to qualify something as hemp. Congress changed that in the fall and said, no, it's all THCs. And then we're in addition going to set a 0.4 milligram per serving of THC cap on hemp products. Well, that changed. What happened? At the state level, but Senate Bill 56 was passed and also included a beverage carve out for hemp infused beverages like the products that Wes's company produces. And that carve out would have lasted coextensively with the timeline for implementation under the federal level. Governor DeWine vetoed the hemp beverage provision. I disagree with that veto. To me, there is a marked difference between hemp-derived beverage products that would have been sold through the existing, 3-tier system, bars, restaurants, places that have liquor permits, right? These are products on the beverage side that we have a better sense of how to regulate, how to sell, how to produce those products, right? Because we know how to sell alcohol. Bartenders, people who sell out, they know how to check for IDs. There's a whole system there. There's an enforcement system. So just to be clear, the bill that OCAN and a lot of folks supported included that beverage carve out that Governor DeWine vetoed sort of without telling anybody. And that's unfortunate. But one of the reasons why we saw all of this action at the federal level, which was the genesis for the timeline under Senate Bill 56, is because so many people were selling products, marketing them as hemp, and they weren't. They weren't regulated. Like, I agree with Wes. There's a difference between what the Ohio licensed operators were doing and the products that were being sold at a lot of these convenience stores, gas stations, and vape shops. So many of those products were coming from out of state where they were not regulated as heavily. And so we ended up in this situation where we had a legitimate public health concern on our hands here in Ohio. That concern was sort of throughout the country. From a consumer standpoint, Adrian is right. People still continue to have access to the cannabis products that they voted for when they passed issue 2 at each of the regulated licensed marijuana dispensaries throughout the state. There's, I think, 204 of them open today, and 2 or 3 dozen more that are going to be coming online here in the next few months. Senate Bill 56 also raises the cap for those new dispensaries to 400 throughout the state. I have my own issues with other provisions of Senate Bill 56, which I'm sure we'll get into over.
I'm going to want to get even more to the consumer side. That's not just based on what the industry's doing and what's available. I want to make sure Ben gets a chance to chime in if he wants on this general question, looking on the sort of industry side of things, and very helpful. Thank you, Tom, for providing that background and perspective on where we are and how we got here. And I think it's among the challenging things I have, not just in teaching these issues to students and talking to people about it generally, but the cross-cutting and almost dizzying nature of the state and federal evolutions and the way in which those echo in every direction is such a huge part of the story, and yet hard to capture in any setting, let alone limited time we have here. And so with that, Ben, I kind of shift to you, and if you want to sort of speak to your take on SB 56 on the producer side, and then I'm going to want to turn to some consumer-based questions.
Absolutely. I think one thing that's running through all of this, right? There are different industry interests, but just zoom out. What is all this actually supposed to be about? It's not supposed to be about, is something okay, right? We should be beyond the moral, the moral judgment components of, does an industry have the right to exist? It does have the right, and it does exist because the people have said that that's what's supposed to happen. So I think at its core, Senate Bill 56 is really targeting safety. And candidly, it's safety with an understanding that there's a decrease in competition to some extent. And I think that's a judgment that was made, that there needs to be a decrease in competition because there was too much supply, there was too much competition, and the competition involved unfair guardrails put on the state licensed operators that have done all the things correctly, played by all of the rules, spent the decade to get things standing up. And then to the point that Tom made, you end up with out-of-state product being popping up in gas stations, masquerading as something else. But I think that's exactly the point. We'll get to the federal thing later. But this is about, at its core, this is about safety, even if there's a hit for some period. And I think, again, the law changes it to some extent to create more competition, but or to encourage the continued existence of existing healthy competition. Without federal action, this is all just speculation, right? What will be the impact? What will be, without the change to federal law, you still have state operators with a 280E subsidy against them, right? Which I think is a subsidy to the benefit of anyone operating something that is going to provide easy access with no guardrails. And I think, putting up a guardrail where there isn't a danger is a problem. I think there were too many guardrails in place with respect to the state licensed dispensaries. But having no guardrail, having no fence where there is actually a cliff that people can fall off of, I think is the other end of the spectrum. Many states have played with this and come up with different answers. I think that's how it's supposed to work when the federal government doesn't step in. And I think I'm happy that our state is at least engaging in this conversation to say, what is the answer actually supposed to be? And I think, kudos to Governor DeWine for saying, I'm going to take an initiative and do what I think is the right thing in going in that direction. That if the federal government hasn't acted, you end up with what you're supposed to have is states' rights and the states acting as laboratories of democracy, which is a great thing because then you get the federal government responding to that. That's exactly what we have going on. It's working the way it's supposed to. It's just the federal government, it'd be great if they could step in before the laboratories of democracy turn into meth labs of democracy.
Well, I appreciate that metaphor, and I especially like, and I think it's a very valuable framing that I'm going to continue forward as we sort of shift to the consumer side, because decreasing competition is likely very good for existing licensed providers here in the state, whether that's the growers or the sellers, but taking out the unlicensed folks that we're working through, intoxicating hemp products means ultimately less product available for consumers. In addition, and I think it's one piece that I want to kind of lean into for those tuning in and thinking about the consumer and even patient side of things for folks in Ohio. As I understand it now, any effort to go out of state to secure product, looking for the competition that was necessarily coming from Michigan, from other states that provide licensed products, now that's entirely illegal under Ohio law and subject to potential criminal punishments. My understanding is that one of the challenges Ohio operators had faced for quite some time was that prices were much lower in Michigan. I believe they've had a tax increase. Ben, you mentioned the federal tax realities where the 280E exception to deductions made the cost of being a licensed cannabis operator that much more expensive, all things considered. And so there's a lot of cross-cutting competition realities. But for the consumer, whether it was somebody who had gotten used to purchasing THC beverages at a local liquor store, whether it's somebody who for a variety of reasons weren't able to or interested in going into licensed dispensary and were happy to have product elsewhere, what should be said to them? I assume it's go to the licensed dispensary to get your product, but to the extent that it's not just a change in the channels of distribution, but also that SB 56 includes risk of criminalization. What do consumers need to know? What should be part of a conversation going forward to ensure that consumer interests and ultimately individual rights are protected for those who voted for, and obviously the whole state did, having a legalized market, but with a variety of additional rights and opportunities that are part of it, that it seems that SB 56, one might say tweaks, others might say changes dramatically. And so, Adrienne, I don't know if you want to speak to those concerns.
Happy to. So first of all, you brought up the Michigan point, and I think that that's been a common point brought up with Senate Bill 56. At the end of the day, this was already against the federal law. And so I think a lot of issues with Senate Bill 56 will come down to enforcement, and we don't know necessarily what that will look like. What I can tell you is absolutely, were Ohio operators concerned about Michigan? Sure, they have incredibly low prices. When you look across the country, they're some of the lowest prices. We just happen to be right next door, which is not always helpful. At the same time, you said they have a tax increase. They're also having some issues with their market. Our prices are going down, and I think we'll continue to see those go down. So that just to level set. But we're talking a lot about competition and what Senate Bill 56 ultimately did with it. But why is it a competition with intoxicating hemp? And I say intoxicating hemp. It's because they weren't selling hemp. At the end of the day, they were selling marijuana products. That's the only way it became a competition. And they were never supposed to be selling those marijuana products. Separately, when we talk about the beverages, there's certainly a market out there for the beverages. And I think there's a safe way to move forward with the 3-tier system. We're talking about, again, a regulated framework. But at the same time, as we talk about these beverages, let's call them what they are. They're not hemp beverages, they're marijuana beverages, and they always were.
Thank you. I appreciate that. I think Wesley may have something to say on this front. I noticed in the Q&A, somebody also raised the concern about CBD products that ultimately, as much as the federal law is changing, it's only zeroing in on criminalizing THC-related compounds and not CBD, but there's an ongoing concern, I think, understandable. And maybe, Wesley, you can speak to this, that, once the THC products are not allowed nationally and now aren't allowed in Ohio, that it necessarily limits or dries up the CBD market as well.
Thank you for that lead up. I would like to add a pretty good bit of context to that. First couple things, as far as the THC dry up across the U.S., I think you will see, less and less farms cultivating hemp products as we move into the future here. With that being said, you've got states like South Carolina, you got states like Missouri, you've got states like Wisconsin, Illinois that all have THC beverage carve-outs within their legislation. So with that being said, Ohio's in its own way right now. And as we move forward and as these things become or come to light, you're going to see, or what I feel that you're going to see is you're going to see a normalization of those type of beverages across the market. We definitely understand that there is this product that's out there that's shaking up a lot of industries, and that's the beverages. I think that's the one that's most socially acceptable right at this moment, between that and gummies. So to sit there and say we're going to turn our back completely on a $28 billion a year industry and not have some sort of carve out, even if it cuts that industry in half, I think that we're still there 12 months from now. So only time will tell. November is going to be that real time when we can decide what we do as an industry to move forward. But, you know, marijuana itself runs conflict at the federal law. So does that mean that these states that have beverage carve-outs on their books, they just become internal state programs? You know, that's essentially what marijuana is doing on the flip side right now. You know, we're running through the category of a federally legal program that may actually end up being state by state program before this is all done. Marijuana has multiple brands across the country. You'll see same brands in Michigan, you do California. You know, there's contracts that are developed there to make those brands viable in those markets. So with that being said, I'd like to jump back to a little bit of the consumer side of this. First off, I got to say to the consumers that are here on this call, I'm sorry that we're all going through this. This is rough waters that we will get through. However, when we talk about safety and purity of products, you know, at the end of the day, the hemp products that were coming through, the real true blue hemp products that were coming through, were subject to a higher testing standard. And before everybody flips out on me, here's the answer. The mycotoxins inside the Ohio cannabis program, they are allowed to remediate mycotoxins, whether that's through irradiation, whether that's through extraction. If that same mycotoxins was found on any of my plants at my farm, that's a complete and utter destroy of that farm. I cannot move that product into any market. And furthermore, irradiation, yes, it does kill the mold that's present on the plant, but you're still looking at dead mold spores as it rolls through the processing of that product. So with that being said, at some degree, we were actually tested to a higher standard than the current marijuana program here is in Ohio. And as far as the consumers are concerned, I don't think the consumers are happy with where we are as far as marijuana goes in the state of Ohio. Look at OCAN's Facebook, Twitter, and Instagram posts. It is nothing but negativity coming across those. So if the consumer was really happy with the way Senate Bill 56 shaped up, you would think that they'd be sitting on those posts giving 2 thumbs up, and it's quite the opposite.
An excellent point to continue to reflect on just how we judge what consumers want and how they want it. I think product safety, accessibility, and then of course we all want it for free, right? Nobody wants to have to pay it all. So there's always a ongoing challenge. And I joke on that front, but you know, the surveys that we've done of medical marijuana patients here in Ohio have always leaned into the cost issue, especially relative to Michigan, relative to what people hear about or maybe experience traveling in other states. And so again, with the consumer in mind and with the background we've already talked about, I don't know if Tom or Ben, you want to jump in before we shift to that big bad or maybe big good federal story that's looming as well.
Doug, just really quickly to go to Wes's point about our Facebook, Twitter, whatnot. Absolutely, there are many activists who are very passionate. However, most Ohio consumers don't live their life on the internet. So I would urge everybody to leave their basement for a minute, maybe turn down the phone and actually go talk to Ohioans if you really want to see what they're interested in.
Again, Tom and Ben, I suspect you talk to Ohioans sometime. Any take on where consumers are and what they're thinking and talking about these days?
Yeah, so there's a gas station close to my family farm in Lancaster that it is the perfect microcosm of some of this conversation, right? For years and years and years, it was the tobacco display, right? And then you'd see the kind of unregulated, that other thing, whatever it was, display. When I think the intoxicating hemp, which again, I think is a misnomer because the federal definition of hemp was supposed to be cannabis sativa that's not intoxicating. So the fact that we've twisted it into, intoxicating hemp, right, doesn't exist. It shouldn't exist. I think by the original definition, the fact that an industry was made out of it that then showed up in that local gas station that then started to occupy 40% of the shelf space in that gas station. And then as this played out and the regulation came back into effect, you saw the supply dwindle and then ultimately go away. What's it replaced with? I think that's the consumer question that I care most about at that level, right? And how do we get additional ease of access to regulated products, right? How do you view a dispensary as not a head shop where there's a stigmatization? You don't have to buy a tie-dye t-shirt. They're not for sale. It's regulated product. It's a place where people should feel comfortable going if they meet the criteria for purchase. But in that gas station environment, what's the next thing that comes along? What's the next thing that never made it onto the controlled substances schedules? There's the whole saga over kava, and that's coming out of the fact that it was a product from the Federated States of Micronesia when it was a U.S. protectorate, and they didn't ask them what should go on the schedules in 1970. That's why it's not on there. That's the only reason. If they'd asked them, it probably would have been on there. But now it's a tea that you can buy online, or you can go to a lot of grocery stores and get kava tea, and doesn't seem to cause any harm to the level where people want to do something about it. So if it's safety that we're actually concerned about, is it working correctly even with these changes? No, because I think, again, if there's a hurdle, if there's a psychological, social hurdle that's a barrier to access to the regulated product, you go from extreme access to the perception of limited access. I think the number of dispensaries that have come online that are open and operating, you should have natural competition amongst them. And if you're removing, fully illicit as well as some of the perceived compliant hemp components, I think you're opening up avenues to consumer safety because you're opening up access to highly regulated product that by definition is designed to be safe.
Anything to add, Tom, or should we shift to the federal conversation?
The only thing I'll add from the consumer standpoint, because this is a theme that certainly I talked about every day during the Issue 2 campaign, this theme of access to consumers. The one thing that I don't think gets talked about enough is how important it is for consumers to be engaged at the local level. One of the things that we run into all the time with clients is when they want to open a dispensary in a local community and we're standing in front of city council who's debating an ordinance change or a conditional use permit or whatever it is, you can guarantee that the people who do not like marijuana are going to be at that council meeting. They just don't like it. They don't think it should have been legal, whatever it is. It's always the fact that those are the people who reach out to their city council members, their boards of trustees, to try to get them to oppose a dispensary coming into their community to provide access for consumers and patients. We always have a really hard time getting consumers to participate at that local level. And so the one thing that I will just stress is that the importance of being engaged in the local political activity on this issue, that's just as important as being engaged at the state or the federal level.
I really appreciate that, Tom, and it gives me an excuse to chime in with a component that we've been tracking pretty closely over at the center, which is how taxes work in this context, especially as it relates to local tax dollars. The Issue 2 is, as you know well, included a variety of allocations for the 10% excise tax that now I think is generating, or is expected reasonably to generate, $100 million for the state on an ongoing basis. The SB 56 and other budget changes reallocated almost all of that money, but because the localities which had been given about a third, a little more than a third of that revenue, if they had these facilities in their in their jurisdiction raised, I think, a justifiable set of complaints about the General Assembly seeming to want to take all that money for themselves. And that's been the piece of the issue 2 allegation that stayed in place, that these monies go back to the locality if they have facilities there. And of course, that ends up being, I sense, a big part of the local debates over whether to enable there to be dispensaries or grow facilities and the like. And I think that, I assume, will continue as we move forward in this space. Let's now shift to federal. There's, of course, so much more to talk about with SB 56. Grateful for the conversation about that. But it dawned on me this morning as I was getting ready for this, we're a good almost 4 years into serious talk about federal rescheduling. It was back in October 2022 that then President Biden called on his administrators to review marijuana status as a Schedule I drug. And that didn't get done, though a lot of progress was made before the transition administrations. Lots of speculation about what President Trump would want to do. But then in December, he issued this executive order ordering his attorney general to expedite the process of rescheduling. Well, we're now 4+ months since that took place, or 3+, and not sure whether we're going to get federal rescheduling quickly or perhaps ever eventually. And I am sure there'll be litigation over any change at the federal level. But I wonder if you all are telling clients, are thinking for yourself, speaking to your members about when that's likely to happen and what to be expected at the state level if and when we get federal rescheduling actually on the books. And anybody who wants to chime in, and I guess there's 2 layers to the question. One is, will businesses see an impact right away and are planning around it? And will it really impact consumers at the state level, given all that we've been talking about at the state level regulation and restrictions on how all this is going to work? Will federal rescheduling really mean anything for the folks who are just concerned about having access to product and doing so in a safe and legal way?
Doug, maybe I could jump in on the based solely on the fact that in September of 2023, we worked together and I put out a piece through the Drug Enforcement Policy Center on the topic of, would a Schedule III reclassification help or hurt state operators? Implicit within that, I think, is that's obviously the first piece of the question. Will businesses see an impact? I think part of the federal conversation right now is around access to public markets. That's been missing, right? It's always been this strange situation where you can have a Canadian, adult use operation listed publicly on a U.S. stock exchange, or you can have a U.S. State compliant, federally not there yet, because of the lack of reclassification, operation listed only on a Canadian exchange. You haven't had U.S. operations truly on U.S. public exchanges. If that's part of it at the federal level, that's huge, because that's where you lost all of the capital, right? When you rely solely on private pools of capital, and candidly, not the sophisticated pools, not necessarily the larger pools that would have pension funds as limited partners, for example. Instead, you have the friends and family pass the hat variety, and then the slightly bigger version of that. Some people looking to do Regulation A offerings. BrewDog was one of those. It's a different industry, but you can see the securities laws implications. And no, to some extent, from an operational perspective, I don't think you'd see an immediate impact. I think you'd see a benefit to the viability of the businesses that already exist if they don't have to suffer the consequences of 280E, which prevents them from deducting ordinary business expenses, only reflecting a slightly archaic version of a cost of goods sold. Yeah, that would be extremely helpful. That would be helpful with raising money. That would be helpful with the financial viability, the profitability. Many of those businesses that are being described as corporate interests, et cetera, aren't cash positive, as in aren't a profitable business that's likely to continue without some intervening event. So I think without some federal action that does that, you're not going to see it. So I think the impact to customers, to consumers generally, is dependent on the viability of the businesses that we've already given license to operate. If they don't exist, if they can't operate, then we're kind of back to either the Wild West or a federal government, what would you like to do about it model. And I think part of the concern there is we don't know how, if you just move it to 3, from 1 to 3, that doesn't make dispensaries federally compliant. So you now have a rulemaking process. You have to figure out, how does the federal distribution system, FDA regulated system for regulating substances, fit into an existing dispensary model that, candidly, the dispensaries are probably safer in many ways than pharmacies, at least from a product control, from a security, from a lot of the just general isolation of the business in its own location. It's not integrated in a convenience store effectively, but just with a pharmacy counter in the back. So that piece doesn't get fixed quickly. If you just move it, you're going to create more chaos. The states are going to have that ongoing conversation with the federal government.
And that's right. I'm going to shift to Wesley, in part because you mentioned the Medicare, Medicaid piece of this. Maybe you can explain both what you're talking about in that context and more generally, how you're thinking about opportunities and challenges in light of the possibility, but no timeline certainty for federal rescheduling.
Correct. So first off, I'd like to point out 2 pieces of language here. It's the CMS rules as well as the White House rescheduling language. So when everybody talks about the White House rescheduling, they think marijuana. The whole back half of that White House memorandum was specific to hemp, broad spectrum, full spectrum, containing THC, no THC. I'll drop this in the chat for folks to review, but I have it pulled up on my computer here. And then you have also the CMS rules that directly conflict the Mitch McConnell language, allowing that 3 milligrams of total THC per serving. So there's 2 pieces federally that we're looking at right now that kind of shows that as we move into that November deadline, something has to give, because either CMS is going to be in violation of the Mitch McConnell language, or the White House is going to reissue another statement stating, hey, we need to backtrack because of the Mitch McConnell language. But I also want to point out that statement came from the White House post the McConnell language. So, and it was quickly within about 10 days from the McConnell language hitting to the actual time that the White House did their memorandum. So I think as you see the shifts and stuff coming, there's going to be some moves. And while I think rescheduling to a Schedule 3 is a step, I'm a deschedule or bust guy. I don't think that marijuana should even be scheduled. We understand that it does have medicinal benefits. The federal government holds patents on those medicinal benefits. So for them to sit there and say that it has no medical benefits sitting in a Schedule 1 is conflicting their very patents that they hold. So I think, these have been around since the 80s, in the 90s, when a lot of research was done on cannabis. So I think that this has just been a long time coming. Schedule 3, definitely a first step, but I think we need to eventually get it in maybe 5 or 10 years from now. We need to get to a point where we are not looking at this like a drug anymore. This is a health and wellness product at the end of the day. This product doesn't kill anybody, doesn't hurt anybody, and the effects of this product, even if you've got the most potent THC possible, you're going to feel just fine tomorrow.
Well, so I have a feeling you and Adrian are now on the same page. And so, Adrian, I don't know if you want to sort of jump in, not on the general.
I was going to say, Wes, I think we agree here. No, overall, obviously not holding my breath. I think you learn not to in certain parts when working in cannabis for rescheduling, but the fact that we're having this conversation and the fact that the conversation is being had nationwide, I think is a net positive overall. It's kind of been the rabbit that no one can quite catch for the longest time, but it feels like we're really getting somewhere, at least with the conversation. I do think that's a good thing.
All right, Tom, I'm gonna tap you as lawyer, although Ben could chime in here as well, perhaps, because I'm going to nerd out with a couple questions that I'm not sure I have a good answer or understand fully, but would like your take on. One relates to, if we get rescheduling at the federal level, does that change some of the interstate commerce stories so that, it might be possible for Ohio-based dispensaries to start sourcing product, from other states, if it's only for medical purposes, because that's what rescheduling is focused on. from President Trump's executive order. And as I understand, the thinking here is, it would be very much a medical marijuana reform. And then I guess sort of connected to that, one of the things we've seen in our surveys of marijuana medical patients is a concern about the risks that come with this still being a federally illegal drug, the possibility of job sanctions or limitations on a range of other rights from being a cannabis user. We're even seeing a federal Supreme Court case about that with respect to gun rights that's currently pending. Does rescheduling, again, I got to say if, though I want to say when something like that happens, change some of those other echoes that have been, kind of persistent legal concerns, even as states have done their levels of reform, but federal prohibition has still been steadfast.
So I don't think it changes the dynamic from an interstate commerce perspective. Like there's a very interesting argument, that the dormant commerce clause already allows interstate commerce of marijuana transactions in the industry, and that these these like intrastate markets and these state silos like violate that dormant commerce clause doctrine. I don't think we have enough time. I think we have like 9 minutes left to sort of walk through the entirety of the dormant commerce clause analysis. But I think that argument is there irrespective of what happens with rescheduling, because look, I think Ben's exactly right. Marijuana being moved to Schedule 3 does not make the licensed industry compliant. To sell a Schedule 3 drug or to, in accordance with federal law, it has to be prescribed by a physician. Medical marijuana is not prescribed by a physician. It has to be a drug that's approved by the FDA. None of the products that are sold in dispensaries are approved by the FDA. And those Schedule 3 drugs can only be sold at licensed pharmacies. None of the dispensaries are licensed pharmacies. So I don't think it changes the interstate commerce dynamic. I do think it will have two important changes, however. The first Ben already identified is 280E. When, knock on wood, when I'm manifesting, Adrian, when Schedule 3 actually happens, I think cannabis companies are then exempt from 280E, can start taking standard business deductions. That will give them at a minimum stronger balance sheets, which should help them negotiate better interest rates with their lenders to allow them to be more competitive, which hopefully will result ultimately in lower prices for consumers. But the bigger change, I think, is political and rhetorical. We've all seen when you talk to somebody in Congress or you talk to a policymaker and try to convince them that marijuana reform is a good thing, the first thing they say, well, it's a Schedule 1 drug. I mean, come on now. When it moves to Schedule 3, we're talking about medicine. And then our opponents are in the position of having to say, I don't think we should have access for people to a product that can help their health. And that that just reframes the entire conversation. So I think, Schedule 3, while I also agree with Wes, I'm a deschedule guy. I think that's the only policy at the federal level that makes any sense. I think Schedule 3 helps us get there because it is a recognition that we're not talking about a product that is like heroin, for example.
Go ahead, Ben, get the last word on this front. Then I want to do a little antitrust and then look ahead.
Yeah, I just want to throw this out. It's interesting. I think it's part of the conversation. It's not part of the conversation yet. There was a March 19th, 2026 article in Science, for those who celebrate. And the title of it is "The Right Schedule for Marijuana, Among Other Drugs, Does Not Yet Exist." It's two law school professors, David Posen and Matthew Lawrence. And it reminds me very bizarrely of my note in law school from 20 years ago, which was on the topic of exactly this, that we've messed up the scheduling so much that there's the opportunity for other schedules that aren't 1 through 5, right? There could be a harm reduction schedule as part of what they're proposing. There could be a general socially acceptable use schedule. If the federal conversation is happening right now, I think that should be part of it. I mean, I think we know of a certain member of the current administration who doesn't necessarily love and isn't particularly thrilled with what the FDA has done historically. So I think there's a meaningful opportunity for that conversation at the federal level. We should be having it.
Yeah, and what I find most depressing here, and say to my students regularly, is getting Congress to do its job is challenging enough when it's something that should be as simple as paying for TSA workers. To imagine them getting together anytime soon, though, I like to believe, and certainly what we saw with the ongoing pendulum swinging over hemp and a range of things that relates to, they can get things done, just not always in a entirely thoughtful and clear way. And so I'm all for being at least ambitious in recommendations. So and thank you, Holly, for continuing to get links into the chat. So for all of you looking for the articles being referenced by various folks or materials, please be sure to check that out and click through to the various links. Okay, this will be a quick one, in part because I think some of you may have some connection to the ongoing litigation, but Attorney General Dave Yost here in Ohio brought an antitrust suit. And I don't know enough about antitrust law. I don't know enough about the cannabis industry to have any confidence what that actually means and what its impact might be. But I still think it strikes me as a significant, if not change, sort of new chapter in the regulation of this industry, because I don't think we've seen, although maybe you all know better than I do, other states with attorneys general trying to use antitrust law or other similar mechanisms to change the dynamic of what's going on in the regulated industry. I will just sort of open it up if anybody has comments in general on this kind of business enforcement. Obviously, it comes in the wake of what I think we all understand and was represented by Governor DeWine's veto on the intoxicating beverage issue, that our current governor doesn't like any of this. But at the same time, it seems as though the Attorney General is trying to put consumers over what he's concerned about, certain business practices, and eager to hear any reaction or thoughts or knowledge just about what that lawsuit represents and where it might have an impact on either what dispensaries are doing or what consumers can expect in the future.
I would just briefly say that obviously we don't know where this is ultimately going. We haven't seen all the facts come out, and the investigation is ongoing when it comes to this. Yes, this is kind of new for the marijuana industry, but it's certainly not new in other industries. So I don't think it's that surprising that you start to see some of these things that other industries deal with, we're seeing here as well. Again, we just don't really have all the facts though, and so waiting to kind of see.
Very good. And yeah, that's a little bit of my take is, when you're starting to get sued by the Attorney General for antitrust, that's a sign that the businesses are being treated like regular businesses rather than, obviously being subject to criminal enforcement actions or other things that is the historical reality of a federally prohibited substance and the businesses involved in moving it forward. Okay, look ahead a bit. We've got a bunch of Q&A questions. I'll try to capture some of those while you all are answering the hardest question of all, which is, we've got an election that remarkably now is only about 7 or 8 months away. We're going to be voting on most of the folks who make the laws and enforce the laws here in Ohio. There's also a big midterm election at the federal level as well that could shift power in Congress and otherwise reverberate through the country in different ways. Any kind of hot takes of a particular election or a particular person that you think we ought to be thinking about or following closely? Obviously, the two gubernatorial candidates, I found it interesting. I think I saw Amy Acton, the Democratic or the expected Democratic nominee for governor, complaining about SB 56 on some social media. I vaguely recall expected nominee Vivek Ramaswamy expressing discomfort with issue 2 and saying he was going to vote against it, but based in part because it was still federally illegal. So we'll see if that changes by the time we get to debates and a vote. But either the gubernatorial candidates or other folks running this cycle, do you think any of them could move the needle on any of these issues? Or is that just me thinking that, of course, everything's about cannabis policy and nobody else will want to talk about anything else?
I would just generally say, I think it's interesting, even since issue 2 was voted in, we've seen a big change in how lawmakers and statewide officials feel when it comes to cannabis. I think that issue 2 really showed that this isn't a partisan issue at the end of the day, and it was something that Ohioans want. And so I'm sure each lawmaker has their own ideas, their own thoughts. Again, when it comes to cannabis, we're kind of building the plane as we fly it. So we are still going to see changes in the next couple of years. We're still going to see changes in regulations to make sure that we get this right. But generally speaking, it's no longer the idea that I think that if one person gets in, it's the end of the industry, or if another person gets in, the industry will thrive. I think generally speaking, a lot of lawmakers saw with issue 2 and those who voted for it that it is something that Ohioans want, whether you're a Republican, Democrat, Independent, or you just don't pay attention to politics at all.
I would concur with that sentiment. I don't think that any one politician jumping in. I think if anything drastic would be done moving forward, it would be a collective effort versus a single individual. But I do think that, there's going to be a slight remember in November thing that goes on with certain areas that may have been, let's call them purple areas, that this issue might end up being the driving force on a candidate being elected or unelected.
Thank you. Helpful. Ben, Tom? Go ahead.
So I think we're probably looking at something that's closer to status quo, regardless of what happens in November, at least here in Ohio. It will certainly be nice to have a fresh generation. One of the things that we saw certainly during issue 2 was that this marijuana reform and marijuana policy is not really a partisan issue as much as it is a generational issue. But I think we have to remember who's sitting in the governor's chair is just as important as who is surrounding the governor in that chair, right? Who's going to be the next director of the Department of Commerce? Who's the chief of staff? What are their views on these issues? In addition to what are the results of the legislative races, right? Those low information races that people don't necessarily pay as much attention to. We saw with Senate Bill 56, right? That's where these policies really gain traction, is through the legislature.
Yeah, if I were to speculate politically, which I generally tend not to do, my guess would be that there are existing other issues that are going to predominate and continue to predominate, and new issues we haven't even brought into focus yet that will arise between now and November that will be infinitely higher priority for public conversation as well as for individual legislators and politicians to address. I think you could zoom out and think about the ongoing federal state conversation, similar issue as existed with cannabis around regulation of AI. Ohio with massive potential investment in that conversation, vis-a-vis the data centers, the potential chip processing, local component. I think that, the obvious international situation currently, going back to my favorite local gas station, I think literally the price of gas, all of those things much higher up the order of priorities than, unfortunately, or in some cases rightfully, but then this conversation, what should happen. Beyond that, no crystal ball there, but I do think we'll have other things to focus on.
I'm tempted to joke, Ben, especially looking at, our headlines these days, that having consumer access to a product that can supposedly help mellow folks out might be a priority against the backdrop of all that we're faced on a day-to-day basis. But I do want to pick up on apologies that I can't easily capture all of the Q&A questions, but one that I've always given some thought to, especially in the wake of what Ohioans voted for and where we are now, this sort of theme of treat cannabis like alcohol, and especially with the growth, and Wesley, you talked about this, of THC beverages, and even the way in which the Ohio General Assembly carved that out, that the prospect and possibility of really having truly parallel regulatory structures seems in the atmosphere, and yet there seems still to be an awful lot of differences, both in terms of access and in terms of, a range of products. And I would also say, consumer understanding of those products as well. And I guess this is sort of a very ivory tower academic-y kind of question, but it's one that I think I'm eager to take advantage of this panel to get your perspective on. Is that still the right way to think about these issues on a regulatory, industry, and even consumer basis? It makes a lot of sense, I think, as we move from conversations about medical access to adult use, that here's another product, an intoxicating product, and my sense has often been, the campaign is effective because people are comfortable with the degree of regulation, maybe not always the price point for alcohol, and want to imagine another intoxicant that's regulated and available in a similar kind of way. But is that really the right way to think about these things going forward once we have legalization in place? Obviously, we've got unique dispensaries that now serve the limit where people can buy these products. My understanding is, especially with the interstate commerce issue, it's much more expensive to produce these products in state because they have to be in state right now. But if and when federal reform, I think you all mentioned descheduling as your preferred approach. Does that come with then, yes, this will end up exactly like alcohol, accessible in all the places that alcohol is accessible, structured and industry players exactly like alcohol is? Or is that really just a simplistic way to say, let's not radically change the way we think about regulating these products, but in fact, the alcohol model is not root and branch what we want to replicate if and when we ever get to a stage where the federal government treats this product similarly?
Well, I'd like to lean into that a little bit. I know I've mentioned the CMS here a few times, Center for Medicaid Services Program. Something has to give with legislation on a regulatory front post Senate Bill 56. Right now you're capped at 0.4 milligrams per container in the state of Ohio. As the plant grows out of the ground, that's an impossibility, being that Ohio doesn't have a work in progress or safe harbor exemption within this bill. We had it before it was vetoed with the beverages. However, if we're talking about, let's put beverages on the back burner for a second, and these products that are going to be going through these APO or ACOs through the CMS program would in fact violate the very Senate Bill 56 law. So Ohio Investigative Unit is now the controlling enforcement arm of both hemp and marijuana. Are we going to start arresting doctors when they start prescribing these products to the patients because they didn't buy them in dispensaries? And furthermore, you can't buy hemp products in dispensaries. There's no mechanism to get a hemp product, full true hemp product, through a dispensary. So, and the way that the Medicare Medicaid program is put out, that it has to go through an ACO. So even the medical marijuana guys wouldn't qualify for that. So in turn, we have essentially made anything outside of isolated CBD illegal in the state of Ohio. So we cannot even properly administer this new program for Medicare and Medicaid research. So as we look forward, I think there has to be change. I don't think that we can sit idle in the current status, but it needs to be smart changes as we move forward.
So I would just say overall, when the campaign, obviously it had that tagline, and I think it's an idealistic look at how we eventually would like to treat cannabis is like alcohol, because they can be very similar in some ways. Of course, there's going to be differences. And in all fairness, the alcohol industry does kind of have a few decades on us when it comes to state laws and policies that they put in place and work to build up to. So again, we're going to see a lot of changes when it comes to cannabis. And I think that that's still a northern star in some ways. When we can look at it, it's a lot easier to compare, apples to apples, obviously. But there are going to be times where it's apples to oranges when it comes to cannabis via alcohol. But again, overall, when we talk about what Ohioans wanted, they did ask for that. They did ask for, cannabis to be treated like alcohol. They didn't necessarily ask for synthetic THC to be treated like alcohol. So again, as we move into the beverage discussion, I think we really need to reframe to be, these are marijuana beverages and they should be sold as such.
Go ahead, Ben.
Yeah, I mean, I guess there's just one little piece of the is
I think we've lost your connection, Ben. So, and if Tom, you want to jump in while hopefully we get Ben back.
Yeah, I'll build a little bit off of what Adrian said. When we talked about regulating marijuana like alcohol, it was really a conversation of let's regulate it, sell it through licensed channels to people who are 21 and over. It was not necessarily an endorsement of every single regulation or rule that applies to the alcohol supply channel, because in some ways they are apples and oranges, particularly with the effect of 280E. It does not apply to the alcohol space. So it's really a high level framing of the issue. Responsible adults can make their own choices about what they put in their body with an overlaying, regulatory framework to ensure the safety of those products.
Thanks, Ben. You seem connected now. Go ahead.
I'm glad to be back and simply agree with Tom's clarity on the point.
Excellent. Glad to hear it. I don't know if anybody wants, we got a minute or two left. I, definitely want part of that minute to say thank you to all of you. And also thanks to our audience that's stuck in large numbers as we've talked about these sets of issues. But I don't know if folks want a closing word. It's got to be quick, but I'm happy to give you a last sentiment to leave our audience with, or again, I think the things to watch out on or anything. Obviously we couldn't cover thoroughly every issue that needs to be discussed in these spaces, but eager to have you flag anything that either we didn't cover or you want to make extra sure our audience doesn't lose sight of in the weeks and months ahead.
I'd like to add one last thing, because I heard Adrian say something a minute ago about synthetic cannabinoids. Our beverages have never been made with synthetic cannabinoids. I actually brought some proof in the pudding today from different OCAN providers. Every last one of these products, based on USC 16390, are hemp products, cultivated in the same exact way that we can cultivate natural produced THC in the open market. So either these test results are wrong or I'm right.
Well, Wes,
All right,
I'm thrilled to see you visiting the licensed dispensaries and seeing how easy it is to do so as an adult Ohioan. Turns out that Ohioans can still go to those licensed dispensaries and you know exactly what's in those products. That's all we want. You can say your beverages don't have X, Y, and Z. We don't know that about anyone else, and we're taking your word for it at the end of the day.
So I got one last sentiment. Then if that's the case,
we could go all day here, Doug.
Yeah, I know. I'm gonna knowing we're wrapping up, I'll give you the last word, Wesley, and then let Tom and Ben chime in too.
With that being said, and OCAN taking the position of they want to know what's in those products, would OCAN come out and publicly support those ODA processors to receive licenses to distribute products directly to you guys?
Is it my turn, Doug?
Sure, go ahead.
Well, first of all, when we talk about OCAN, like I said, I think there is definitely a way forward with beverages. We just have to find a safe, regulated way to do it. And again, as we talk about these beverages, let's call them what they are. They're marijuana beverages. They're not hemp beverages. And so again, there is a regulated structure there with alcohol. There's a regulated structure with cannabis. That's what Ohioans have wanted to. I think there is a path forward here. We just have to figure out how exactly to do it in a safe way.
Tom, Ben, last thoughts?
Go
ahead, Ben.
I think I've got an iffy connection, Doug, so I'm not sure if I'm actually coming through.
You are, we got you.
Okay. Yeah, I'm just looking forward to seeing fewer products in the hands of kids, I think, from a safety perspective. I'm looking forward to see the viability of state operators prove itself. Can they actually, to some extent, given the removal of certain impediments, can you operate? And if you can't, then the state should figure out a way to make room for those who can.
I'll just close by again thanking you, Doug, and Holly, and everybody at the Drug Enforcement Policy Center for having us. And given my experience in the cannabis space, I can't wait to be here next year talking about the exact same issues that we talked about here today.
Yeah, we will try to stay on it, and it does have a Groundhog Day quality to it, but that's part of the reality. And in fact, the issues change, but the dynamics and the challenges certainly remain. And so I'm incredibly grateful for all of you giving your perspective and helping us understand it from that angle. And we will continue at the Drug Enforcement and Policy Center to try to provide as many perspectives and understandings of what is always an incredibly dynamic area. Everybody should have a great afternoon. Stay safe out there. Thanks again to our panelists. Really grateful. And thanks again to everybody at the Drug Enforcement and Policy Center for making this possible. Be well, everybody. Take care.